Good morning, everyone, and welcome to the Legal Practitioners FICA Compliance Training. The training is being facilitated by both FIC and the LPC. And before we move straight into the presentation, kindly allow me to introduce the presenters for today's session. I'll start with myself. My name is Thabole Peana. I work for the LPC as the Senior Manager, Risk and Compliance. Then from the FIC side, we have Ashley. Ashley, please introduce yourself.
Good morning, and thank you so much for the invitation and the opportunity to join with yourselves today. My name is Ashley Moy from the FIC. I sit within the Compliance and Prevention Division, so not that team that is responsible for inspections, but that team that is responsible for the issuance of guidance as well as public awareness.
Thank you, Ashley. Next, we have Michael Campbell-Atkins. Michael from FIC.
Sorry, I forgot about my microphone for a second. Good morning, and yes, I'm in the guidance and prevention team, so in Ashley's team at the FIC. Thank you for giving us this opportunity this morning.
Thank you, Michael. Then from the LPC side, we have a presenter, Mr. Alfred Horner. Alfred, please introduce yourself.
Good morning to everyone. My name is Alfred Horner. I'm the Director of the Eastern Cape Provincial Office of the Legal Practice Council, one of the 9 provincial offices of the LPC. Thank you so much.
Thank you for those introductions, colleagues. Before we move into the session itself, I would just like to highlight to everyone who is attending here that any comments, any questions that you might have, please at this point, post them in the chat and we will be monitoring those comments and questions, which will be addressed at the end of the session. Otherwise, if there are any areas that might require the engagement, we will unmute that specific speaker who wants to bring any matter to the attention of the presenters. So on that note, colleagues, allow me to hand over to Ashley to start with the presentation. Ashley, over to you.
Great. Thanks so much again. So again, good morning to everyone. We were asked today to provide you with a snapshot not only of what your obligations are in respect of the FIC Act, but also maybe to touch on some of the, the very important going-ons that South Africa faces currently in respect of the grey listing. So I'm going to touch a little bit on that. And like we always do in our sessions, before we even get started, we want to just take you through some of the acronyms or the jargons that we like to use. We're going to try our hardest not to make use of them. But I think just from, if you've read any of our articles or if you've gone through any of our guidance products, our PCCs or guidance notes, you'll tend to see that we're creatures of habit and we like to slip in a good acronym here and there. So I'm going to start off then just by going through an acronyms page. If you want to take a picture of this, I would recommend it. So when we do start talking, if we forget to tell you what the acronym is, you at least have a reference point. So first and foremost, when you listen to us today, there's probably going to be about 4 or 5 acronyms we're going to make reference to quite a lot, specifically in respect of ML, TF, and PF, because these really are the principles that underpin. And then obviously there's the opposite of it, so AML, CTF, and CPF. So when we're talking about AML, we're talking about anti-money laundering. Obviously, money laundering then is the crime that we're trying to eradicate. The FATF, this is very relevant when you're talking about grey listing and the mutual evaluation process, and that's the Financial Action Task Force. The FIC being the Financial Intelligence Center, which is all DNFBP supervisory bodies, so designated non-financial business and professions, of which the legal profession finds yourself within that particular category. All it means is you're not a financial institution. So you're not a bank or you're not an insurance provider, so you fall outside of that category. When we talk proliferation financing and terrorist financing, Michael is going to take you through that in a little bit more detail, but that we refer to PF and TF. Then there's targeted financial sanctions, which sits very closely with PF and TF. Again, there's quite a long discussion around targeted financial sanctions today. When we talk RCR, I know some people think this is a swear word whenever we bring it up, but it relates to the risk and compliance return, specifically for your industry that sits under a directive, and that's Directive 6, which we'll talk about a little bit later. Org ID number, this is very relevant, especially when you call into our call center. The org ID numbers are linked to you and you're linked to us. It is your unique registration number with the FIC. So if you're thinking to yourself right now, oh gosh, I don't know what my org ID number is, we do have contact details for you that we'll make available right at the end. The org ID numbers, like I said, it's your ticket to submit your RCR, it's your ticket to submit any regulatory reports through to the FIC. And if you don't have an org ID number, then that means that you're not registered with the FIC. DNFPP, we spoke about an RMCP, also a bulk of today's discussion. And this really underpins all the compliance obligations that is set specifically in Section 42 of our Act. And that relates to the risk management and compliance program. Now, it's not just a document. It talks to the actual program in and of itself. So how you identify risk, how you define risk, how you apply risk, what are the controls that you've put in place to mitigate those risks. And again, the Act in respect of Section 42 is very clear in terms of a guide of what those controls are, and it's going to serve a very big portion of today's discussion. PCCs, so PCCs are very relevant documents. They aren't necessarily an extension of the Act like a directive, but a PCC or a guidance note really provides the FIC's interpretation on particular matters, and it assists you in unpacking and understanding what the compliance obligations are in respect of the FIC Act. We're sitting on about 56 or 57, if I'm not mistaken, PCCs, some of which have been withdrawn when our legislation was updated, but they do hold precedence, especially when it comes to our enforcement matters. So, you know, after an inspection, if there's finding, and enforcement has to be applied. CTRs, STRs, and IFTRs, now these talk to your reporting obligations. Again, we are going to talk about these a little bit later. CTR is cash threshold reporting, STR suspicious and unusual transaction reporting. And IFTR, I'm going to tell you now, you do not need to worry about IFTR, but you are going to see it in the Act, and it is an obligation. It is not your obligation. This is only for banks and financial institutions. So that relates to international fund transfer reports. All right, so those are all the acronyms. I hope it gives you a little bit of context. We'll go over 3 definitions which are very key, again, which is what our legislation is about shortly. Because we are making these slides available to you, we've put some working links or click-through links for you for a little bit more reading. So if you want our updated guidance booklet, it is available, and there's a bit more reading on our directives. All right, so we can move on then to the definitions. And this, again, is really just to set the scene. You know, if you do know it already, that's fantastic. If you don't, I mean, that's why we're here today. And these definitions, some of which come, you know, from the FIC Act, some of them come from related legislation. So the Financial Intelligence Centre Act doesn't work in isolation. The FIC Act really just sets the obligations for you as a accountable institution, being legal professionals. The likes of POCA, so the Protection of Organised Crime Act, that act actually defines what money laundering is. The FIC Act does have a definition for proliferation financing, and POC DETARA, which is very difficult. I'm going to have to actually try read it. I can never remember the name. I'm going to read it quickly. It's the Protection of Constitutional Democracy Against Terrorist and Related Activities Act. It's quite a mouthful, but that then provides definitions of terrorism, terrorist financing, terrorist-related activities. So you'll see there's 3 different pieces of legislation that work with one another, but the FIC Act then being the primary one that kind of links to those other pieces of legislation, pulling through definitions and also making reference to certain sections to a lesser extent. So when we're dealing with money laundering, we if we break it down to the simplest form, we're talking about illegal proceeds of funds that you take through some or other process to try and distance those funds from the illegal origin, and then to come out at the end of the day seeming as though it is legitimate funds. And that's where that whole concept of the washing machine came in. Something dirty going in, it goes round and around and around. You add some water, you add some powder, it goes on a spin cycle, comes out, you hang it up, and then it's clean. It's exactly that process. Theoretically, it's considered to follow a 3-step process, but don't get too hung up about the steps. I think it's only relevant to know where you as an accountable institution kind of fit in within that process, because that allows you to know where your vulnerabilities lie in respect of actually being abused by the criminals. And that's always the focus. It's not that the attorney or the legal profession is the bad guy. It's about how the bad guys misuse your profession to do their deeds. All right, so the 3 stages then we refer to placement, layering, and integration. It refers to where the origin of illegally obtained funds is concealed, and the goal is to conceal those illegal funds. So when we look at placement literally, as the name suggests, it talks about putting money down somewhere. You need to get rid of it. It's like a hot potato. You need to put it down. The layering refers to the movement, so moving it around. Again, if you're using the hot potato example, it's literally passing that potato from one person to another person, putting it in the fridge, putting it in the deep freeze, trying to cool it down. And then the integration then is really the benefit. So you're actually able to now use these ill-gotten gains, and they seem like clean funds. And again, back to the potato, that's when you can actually enjoy the potato, call it a potato salad for argument's sake. When you're talking terrorist financing, it's slightly different in the sense that the source of funds isn't necessarily illegal. And I think we've all been around and we've all witnessed 9/11, and we've all watched many movies that relates to terrorism and terrorist financing. There are elements of, abusing charities or non-profit organizations. And then there's also, valid contributions where you'll have people in societies through different cell leaders who actually, with hard-earned money, donate the money towards a terrorist cause. And that's the significant difference between the funding model of money laundering and terrorist financing. It also follows 3 stages in the sense that they need to attract funds, they need to move the funds, and they need to make use of those funds. So again, attracting funds is exactly that, handing out flyers, talking about the cause, people donating funds, or again through illegal activities. So that, whether it's through theft or corruption or whatever the case may be. The intention for the funds is also different if you compare it to money laundering, in the sense that these funds then are used to support terrorist acts, terrorist organizations, or individual terrorists. And the goal of terrorist financing then again is to conceal the nature and the activity, is to conceal the financing and the nature of the actual activity being financed, which at the end of the day is the terrorist activity, and it's what we see in terms of genocide, bombing, etc. When we talk proliferation financing, so terrorist financing and proliferation financing are kind of housed together in the sense that it's the same funding model. It's either illegal or legal sources. It can also follow the placement, layering, and integration. And the difference with proliferation financing then is the intention of the funds is actually to purchase goods and materials to assist in the manufacture of weapons of mass destruction. Again, the goal is to conceal the financing and the nature of the activity. So they don't want people to know that the money that they're collecting and that they're moving around is going to be used to actually purchase parts of bombs or chemicals for chemical warfare, etc. All right. So Michael is going to talk, in quite a lot of detail a bit later around what are the obligations to prevent actually being in a position where you can facilitate the financing of terrorist or proliferation financing, as well as understanding the risk related to the potential of abuse by your organization. All right, so I think that kind of then lays the foundation quite neatly for the rest of the presentation. And I'm going to get into some of the meat then of today's discussion. I'm going to talk to you around the mutual evaluation process and the grey listing process, maybe just give you a little bit of context of where we are currently sitting. And then we're going to get into the compliance obligations when I hand over to Michael. So first and foremost, then in respect of the mutual evaluation report, it seems really like a lifetime ago. We had assessors come from all around the world. It was a FATF mutual evaluation, so that meant the Financial Action Task Force was heading it. There was also the likes of the IMF, which is the International Monetary Fund. And we also then had representatives from our African bodies. So these aren't necessarily FATF members, because South Africa is the only African FATF member, but they were part of our regional body, which we refer to as ESAMALAG, which is the Eastern Southern African Anti-Money Laundering Group, to which we are kind of like a big brother when it comes to AML and CFT compliance, so anti-money laundering, counter-terrorist financing compliance. So on the screen now, and I don't expect you to read it in too much detail, but really this is just the outcome of the findings. So you'll see it split into two sections. The one on top is the effectiveness table. The one at the bottom is the technical compliance table. So there were two different tests that we got taken through all in one process. And this was the report as of October 2021. Now, what it says there I'm going to start with the technical compliance. The FATF has come up with the 40 recommendations. The 40 recommendations talks to all countries. It's not South Africa specific. We all get tested on the same test sheets. And these 40 recommendations really range from how you structure your legal framework to how you interact with other countries, to how you identify and confiscate proceeds of crime, to how you deal with financial institutions and DNFBP, so like your CDD obligations and your record keeping, etc., to things like how do you actually supervise? So how do we go out and inspect? How do we handle non-compliance? So it really it's broken down, and then I beg your pardon, and of course targeted financial sanctions as well as terrorist financing and proliferation financing. These are all your key issues. And they split up. So there's very specific recommendations. And these are technical in the nature that it's kind of like a tick box. So do you have an obligation for lawyers to comply with your legislation? Tick, yes, because you are part of our schedule to the FICA Act. It's very technical. So that was the technical compliance test. The effectiveness test, and again, as the name suggests, is it actually working? So yes, we've said attorneys are accountable institutions, but now what we want to check is, are they actually complying with the legislation? Do they have risk management compliance programs in place? Has the supervisor gone out, done inspections? If they've found non-compliance, have we actually provided them penalties? Now, I'm only singling your profession out because I'm only speaking to legal professionals today, but rest assured, of the 22 entities that are, or there's 22 items, some of them have been since removed, but the test was against all accountable institutions, not just yours. The reason why we focus specifically on attorneys, and we also, or the legal profession, as well as estate agents, is because the mutual evaluation report wasn't too favorable on your industry's understanding of compliance obligations, and it was also not too favorable of the supervision over your particular industry. So if you're wondering why, why is there so much awareness? Why is there so much outreach? Why are there directives? Why do we keep coming up with PCCs? It's not to correct the behavior. Well, I beg your pardon, it is to correct the behavior, and it's not just to get us off the grey listing. It's because they identified a gap of our weakness that we needed to improve on. So if you have a look at the effectiveness, unfortunately, you'll see a lot of lows and a lot of moderates. We don't have any substantials. We don't have any highs. So if you're thinking about it as your test of how effective you were, we all failed. So everyone got below a 50%. If you look at technical compliance, again, you'll see a lot of PCs, which is partially compliant, I beg your pardon, and a lot of LCs, which is largely compliant. Again, we didn't, and unfortunately, we got some NCs, which is non-compliant. If we look at it from a technical perspective, we also failed quite hard. We were then given, so this was the initial test. We were given 1 year through the ICRG process. So it's a follow-on process where we can, work on these issues and then submit it through to the FATF so that they can reassess us. They said within the year that we weren't able to effectively demonstrate a tangible difference in respect of effectiveness. As a result of that, we were then put into grey listing. So in respect of grey listing then, the grey listing took place in 2020, the 2022, 2023. I can't remember the dates now, but we've had follow-up reports ever since then. Now, what these follow-up reports mean is we get given an opportunity on a quarterly basis to go through that list that I showed you already of everything that we've done wrong and to improve on it. So you get a continuous cycle of where you can improve. It's not like you failed the test and that's the end of it. So you failed the test or you partially passed the test, and they give you an opportunity to correct to the point eventually where we need to get off of the grey list. So what did it mean in respect of the follow-up? So we've had a few technical follow-ups. We had one or a formal one released in November. We had one recently released February, March. There has been significant improvement. We do have, I think we've only got 3 technical compliance issues that need to be looked into. So if you think about it, we had 63 odd deficiencies. We way past that mark, and we really are, on the road to getting off of the grey list. I think maybe the last thing that I want to talk about grey listing then is just to show you what the 8 key areas are, or the 8 focus areas. So we spoke about all the technical deficiencies and the effectiveness deficiencies. There was about 63 in total things that we needed to fix. And in an agreement, when we were formally grey listed, what the process is you need to identify the key issues. So if we address the following key issues, then the FATF would be comfortable that they can re-rate us, and then we can get off the grey list. Very briefly, and I'm not going to go into too much detail on them, the first area is mutual legal assistance, and that really talks to South Africa as a whole. So all of the clusters within South Africa, so where we talking from a law enforcement perspective, from a judicial perspective, assisting in mutual legal assistance. All right, so where information is required. Risk-based supervision of your industry, designated non-financial businesses and professions, as well as sanctions. All right, I'm going to talk about this a little bit later. Beneficial ownership information, a massive project that's being run, and this really talks to how do you deal with corporate structures, but it's more than that. It's not just around how do you KYC or what documents do you get for a client that's a corporate structure. It also talks more about law enforcement's access to that information so that they can actually catch those guys sitting behind corporate structures. Law enforcement agencies' requests of financial information, and that again, as the name suggests, is getting access to information pending investigations, which leads to investigations and prosecutions of money laundering and terrorist financing cases. We didn't have enough. And part of the mutual evaluation process is quite interesting, is they don't just take what you say at face value. You need to be able to provide them with case studies. We did have case studies, but I don't think those case studies were sufficient enough. Then there's the identification, confiscation of proceeds and predicate offences. Again, they need to see more examples of how we have actually taken the money away from the bad guys. Right? It's not good enough just to identify that there was money laundering, but we need to actually get that money back and take it and give it back to where it came from. We needed the national risk assessment on terrorist financing. We have done one for non-profit organizations, and we have completed one for South Africa as a whole, but that is currently at a confidential stage, and we're just waiting for the summaries for public consumption. And we say that because there's a lot of very sensitive, delicate information in a national risk assessment. So you can't make everything available to the public, but definitely red flags, indicators, etc. And then lastly, targeted financial sanctions implementation and domestic listing, which is a chunk of what Michael's going to be talking about a little bit later. Okay, so the last thing that I'm going to chat to you then about is Directive 6. This is the one I said a little bit earlier. It's probably a swear word if you hear us say it. And this really sits under that category that I spoke about of risk-based supervision of DNFBPs, which is designated non-financial businesses and professions, as well as then associated sanctions. So there's two directives. There's a Directive 6 and there's a Directive 7. Directive 7 is not applicable to your industry. It's applicable to those entities that were added to the schedules in 2023. But you then fall under Directive 6 because you've always been accountable institutions. Even though your definition changed to bring in legal professionals that work with fidelity fund certificates, so the likes of advocates that receive funds from the public. That was a change to the schedule, but you then would all still fall under Directive 6. And what this requires is for you to be able to provide information of your understanding and application of money laundering, terrorist financing, and proliferation financing risks through a self-assessment through to the FIC. It's an online form that needs to be submitted. In fact, the deadline was almost a year ago, but we are finding very slow submission rates. And even though it is a year past, and even though, yes, we have started with enforcement action for those entities that have not submitted their risk and compliance returns, you either have already or you will very soon be hearing from our enforcement team. The only way that we can try and enforce this one now is through, through penalties. All right, so just so that you can see on the next slide then, these are all the other entities that fit within Directive 6. It's yourselves, estate agents, trust company and service providers, and gambling. Now, the reason we bring this up because we are aware that some legal practitioners also perform the function of a trust company and service provider. Now, a reminder, when you perform more than one activity in respect of the FICA Act, you are required to register separately. So if you are a legal practitioner and as part of your function, you provide trust and company service solutions to your clients, you would have to register twice, one for your legal practitioner business that excludes trust and company services. The last thing that I'm going to say then is just some tips and tricks, because I can already see a question being posed to me about the RCRs, and we get asked a lot. So if when you have a look at the slides afterwards, we have issued a few formal notices. This is just a summary of those notices that we have issued. Now, very simply, you submit one risk and compliance return per org ID. That means if you have multiple branches, if you are registered as a legal practitioner under item 1, or you registered as a trust company services provider, you would need to submit separate risk and compliance returns. When you are filling it in, you need to ensure that your organization ID or your org ID number is submitted and not your personal ID number. Even though the form very clearly says org ID number, I think we're creatures of habits, and if you see ID, you just pop. I almost said gave away my age there, but it's just instinct to pop in your ID number. It makes it very difficult for us at the FIC to link it to your profile. So please bear that in mind. Only one RCR needs to be submitted per org ID. And this is different to the first one because please do not submit more than one. It is a once-off return. Directive 6 was for a very set period of time. It concluded last year already. So it doesn't mean every year now you need to submit a return. We are going to get to that at a later version when we have a more sophisticated and upgraded system that will allow for that. I think a very nice example that we're really trying to aspire to is how SARS does their tax returns. It's seamless information. The half of your information is already captured. You need to validate. So really that's pie in the sky for us. It does pre-validation checks and all the fancy bells and whistles, but we don't have that yet. It was really just to start off the process, which is why it is an online submission on your SharePoint link. We ask you to please keep record of your risk and compliance return submission. Once you've completed it, you can download the confirmation as well as the answers. A very good suggestion for those of you who maybe haven't submitted your risk and compliance return first, go onto the website. Again, the links are available in this presentation and also on our homepage. Download the questions. You don't even have to download it. You just need to open up the PDF, and that will give you all the questions that we're going to ask you. Look through that first, print it even, jot down the answers on that document, and then go to the online submission and populate your information. A lot of the feedback we get is very frustrating because you look at the question, then you have to quickly go look for the information. By the time you've come back, your session is timed out. So just make your life a little bit easier, and maybe even if you're not doing it on paper, do it on Excel or on Word, whatever the case may be, so then you can just copy your answers across into the submission. Again, it's not the best solution. It is SharePoint, so if your screen does lock, chances are you're going to get timed out. So you can't pause and go back and restart the session, unfortunately. The last thing to say then is every question needs to be answered on the form. It will not allow you to proceed to the next page if you haven't answered it. Questions we do get quite a bit from the legal profession is that the question is not applicable to you or it doesn't make sense. I can assure you it makes sense to us in the sense that we are analyzing certain information. And again, be it a limitation, is we're assessing everyone on the same question. So right now, the legal professions don't have different questions to the estate agents, for argument's sake. That is going to come. It's going to be more refined. It's going to be a shortened questionnaire in the future. But right now, we just needed to do the self-assessment. Everyone asked the same questions. If you feel that it's not applicable, there are options that you need to choose. There will be different ranges. So it would be like 0 to 20%. Select that option. Don't worry, we're not going to assume anything from the information. We've got our own methodology in the background that takes that into consideration. Or please, if it's a yes or no answer, select the no option if you believe it is not applicable. So that's the end. I have seen some questions popping in. So before I hand to Michael, I'm just going to maybe quickly look at some of the questions that were posed while I was talking. So yes, the risk and compliance return is submitted once off. It is not an annual submission, not yet. As soon as we've done this round of risk analysis and we've submitted our findings, for grey listing purposes, we are definitely going to be running a new round based off of all of the learnings that we've gotten through this first round of the risk and compliance return. Some of the other questions I think are going to be answered by Michael a little bit later. So I'll maybe just end it there and then hand over to you. Thank you, Michael.
Oh, perfect. Thank you so much, Ashley. So as mentioned a little bit earlier, my name is Michael Campbell-Atkins, and I'm in Ashley's team at the Financial Intelligence Center. Okay, so first off, we're just going to go through some of the obligations that legal practitioners, attorneys have in terms of the Financial Intelligence Center Act. Okay, so ultimately, there is registration, reporting, governance, risk management and compliance program, risk-based approach to customer due diligence, training of employees, and record keeping. So registration, that is number one, as ultimately you cannot submit reports to the FIC until you are registered on GoAML. So governance, that is ultimately you need to have a compliance officer, and the board of directors, senior management need to approve of your risk management and compliance program. Risk management and compliance program, because that's quite a mouthful, I will just be referring to it as an RMCP. Ultimately, it is the document that reflects the institution's approach to risk, how they mitigate it, how they manage it, what controls are in place, and that sort of thing. And of course, RMCP goes hand in hand with the risk-based approach to customer due diligence, because as I'm sure everyone is aware, the FIC Act was amended in 2017, and we moved from a compliance approach, from a tick box approach to a risk-based approach where you do not need to treat all your customers the same. You can devote your resources for higher risk clients, and you don't need to devote as much resources for the low risk clients. So training of employees, that would be ultimately you need to train your employees with regards to your RMCP and what the FIC Act is about. And you would need to provide more training to, of course, the employees that are on the front line or the employees that are going to be compliance officers in the risk function if that is a part of your institution. And then lastly, record keeping. That is just ultimately technical compliance, but we will be pretty much discussing that a little bit later as well. But ultimately, you need to keep certain specific records with regards to your clients and transactions, and it needs to be over the course of 5 years. So ultimately, we're pretty much going to be just discussing these obligations in a bit more detail during the course of this presentation. Okay, so to start off with registration, as I mentioned a little bit earlier, you are required to be registered with the FIC, as you need to submit reports and you need to be registered first. So Schedule 1 items are required to register with the Financial Intelligence Center, particularly where you are accountable institutions. So there are specific definitions that are in place. We won't be going through all of them, but we'll be focusing on the one that is directly relevant to yourselves. And just to touch on dual registration, so if you do provide services with regards to other Schedule 1 items, please do keep in mind you would need to register for those as well. So, for example, a trust services provider or a company services provider under Item 2 of the FIC Act. Okay, so Public Compliance Communication 47A, PCC 47A. This is just the guidance that the FIC published with regards to the interpretation of legal practitioners in terms of Item 1 of Schedule 1 of the FIC Act. So please do take a look at it. This link is also available here, and the slides will be provided to yourselves, but it can also be found on the FIC website. So we pretty much discussed the definition of legal practitioners in terms of the FIC Act, and we just highlight some of the risks and red flags for legal practitioners. Okay, so what is a legal practitioner in terms of Item 1? So it is a person who is admitted and enrolled to practice as a legal practitioner. And of course, being an attorney, including a conveyancer or notary practicing for his or her own account as contemplated in Section 34.5a. Or there is an advocate in terms of 34.2a2, or a commercial juristic entity as contemplated in terms of Section 34.7 of the Legal Practice Act. So we won't be going into more detail than that, as I'm sure yourselves are aware of that legislation. So just one aspect to focus on. So an advocate, that would generally be an advocate with a trust account that accepts funds from the public. Okay, so how do you register with the FIC? So ultimately, you need to be registered on GoAML. So please do access our website, www.fic.gov.za. You would click on register or report and follow the link. And just to specifically mention here, because the slides say you may register as an organization or an individual by completing the required fields, but please do keep in mind you need to be registered as an organization first. So we quite often get questions about people who are sole proprietors, if they are the only attorney working in their law firm, and they ask if they need to be registered as an organization or an individual. Please do keep in mind you need to be registered as an organization if you meet the definition of the accountable institution. So it's organization first, and then if you want to add money laundering reporting officers, or if you want to replace compliance officers at a later stage, then you would register as an individual. So do keep in mind you need to be registered as an organization first. As Ashley mentioned, we are pushing quite hard with regards to the risk and compliance return. So once you had your application processed by the FIC, you will receive an org ID. So please do register on GoAML first before you submit your risk and compliance return. If you do realize that it needs to be processed quite quickly, please do send us a compliance query on the FIC website and provide us with the SHREG number. The SHREG number is ultimately the specific reference with regards to your registration application. But you can send that to us via compliance query, the link for which we'll provide at the end of these slides. Okay, so do remember to attach a copy of the compliance officer's ID and an authorization letter of your law firm. So it will need specific information such as first name, last name, and ID number. Okay, so with regards to appointing a compliance officer, so board of directors or most senior management is responsible for FIC Act compliance. And where it is a corporate entity, a person must be appointed to the compliance function where they will assist management. So similar to other compliance principles, they must have sufficient seniority and must be competent, have integrity, and screened against the targeted financial sanctions lists. So we're not going to go into too much detail today with regards to the last bullet point, but ultimately competency and integrity, it relates to specific skills and requirements. And also, of course, they can't have a criminal record and that sort of thing, but we won't be going into too much detail in that regard today as we are pressed for time. So please do take a look at Directive 8, which can be found on the FIC website, and PCC 57 in that regard, which discusses the directive in more detail. But similarly, as I mentioned, with regards to training, there is a risk-based element that you can use for screening both the compliance function and employees against the competency and integrity. And of course, screening against TFS lists needs to be for all employees. Okay, so just some practical considerations. There can only be one compliance officer in terms of Section 42A, and generally it would be good practice for the compliance officer to register the institution. So the person you want to be the compliance officer should be the person who's going to be registering the institution. And ultimately, if the compliance officer resigns or leaves the institution's employment, then you would need to appoint another compliance officer. So we quite often receive queries asking if we can provide the username of the previous compliance officer. In terms of Directive 2, we will not be able to provide that information. So please note it is on the specific person themselves with regards to the compliance officer and submitting reports. So you would need to appoint another compliance officer, which you can do on the GoML website as well. So if you want to replace the compliance officer, if you want to register a new person, being a reporting officer, then you would, once the profile has been established, once you have the org ID, you would register as a person. And you would need the similar attachments of copy of the user's ID and the authorization letter. Okay. Yes, we'll pretty much just skip over that one. Okay, so training of employees on the FIC Act and the RMCP. So with regards to training, please do keep in mind you need to provide ongoing training to your employees on the FIC Act and your specific RMCP as well. And you would need to be able to demonstrate that training was completed, that training was in line with the employee's role. As I mentioned, you can adopt a risk-based approach, and that the training is ongoing as and when changes are made to the RMCP. So for example, RMCPs an element of it was amended when the General Laws Amendment Act was passed in December 2022. So as a result, you would need to update your RMCP when legislation is passed or on an ongoing basis as well. Okay, so with regards to the risk-based approach and customer due diligence considerations. So just a bit of background with regards to what exactly is risk. So risk is defined as the likelihood and impact of uncertain events on a set of objectives. So uncertainty is a function of threats, vulnerabilities, and consequence. So to apply that specifically to money laundering and terrorist financing, so these are the threats and vulnerabilities which put accountable institutions at risk of being abused for facilitation of money laundering and terrorist financing activities. So there's the potential that clients may use the accountable institutions, products and services for money laundering and terrorist financing purposes to launder proceeds and blur detection, investigation, or prosecution of money laundering. So specifically with money laundering and terrorist financing, these methods would be used by organized crime, by syndicates to cover the tracks of significant predicate crimes that were already committed. So ultimately, this is to pretty much assist the financial institutions and law enforcement agencies to make sure that South Africa does not become a country that facilitates crime ultimately. So applying a risk-based approach ensures that accountable institutions can ensure that measures are in place to prevent money laundering and terrorist financing, and it is in proportion to the identified risks. So ultimately, as I mentioned a little bit earlier, you can treat your clients on a case-by-case basis. You do not need to provide or allocate the same amount of resources to every client that you have. You do not need to apply enhanced due diligence, for example, for all your customers. Theoretically, you'll be able to determine what level of customer due diligence you need for those specific clients. Okay, so risk assessment and risk rating. So you would be able to assign different ratings or categories to different levels of risk. So generally, we go with high, medium, or low risk. Of course, if you wish to, you can add further levels in that regard if you want to. So there's no one-size-fits-all approach, so it would be on a case-by-case basis. So we would recommend that you consider the consequence and impact of money laundering and or terrorist financing from that specific client. Would it be a huge negative impact? And consider the likelihood of money laundering and or terrorist financing risk occurring. So is it likely to occur? Is it not likely to occur? So your risk scale would be tailored to the size of your accountable institution, the range of your products are offered, and your risk rating may change. So do keep in mind that your risk rating does not need to be static, or ultimately it should not be static, should I say. And your risk rating methodology must be documented in a risk management and compliance program. So ultimately, with the risk-based approach, as I mentioned a little bit earlier, your RMCP pretty much goes hand in hand with your risk-based approach and customer due diligence as how you apply your risk and customer due diligence should reflect in your RMCP. So just to touch on the size of the accountable institution and the range of products offered, please do keep in mind that there are two risk assessments that are applicable for accountable institutions. So you have a business level risk assessment and you have a client level risk assessment. So we're just going to touch on those two specific aspects now. Okay, so before we get to that, just to touch on the fact of with regards to the RMCP. So in terms of section 42.2a, accountable institutions are required to identify, assess, monitor, mitigate, and manage the risk that provision of goods and services may involve or facilitate money laundering and or terrorist financing. So you would need to document your inherent money laundering and or terrorist financing risks. So inherent being the risk that is involved before there are controls put in place, and you would implement reasonable measures proportionate to those risks, so that you can accurately assess the risks involved and you can take an informed decision on the basis of your risk assessment as to the appropriate methods, being controls, and the level of verification that should be applied in a given circumstance. Okay, so as I mentioned, with regards to the assessment, you should ultimately have a business level risk assessment and a client level risk assessment. And based on the client level risk assessment, for example, then you can determine which identification and verification documentation you would need. Okay, so with regards to the treatment of risk, so controls include processes, systems, resources, monitoring, reporting, and training. So control must be in proportion to the risk. So higher level of money laundering and or terrorist financing, you would apply enhanced due diligence. Medium risk would be standard due diligence, and low risk would be simplified due diligence. So ultimately, the identification documentation you would need from the low risk clients should be different to the documentation and the scrutiny that you would apply for the higher risk clients. So risk needs to be adequately treated so that the level of residual risk is acceptable and within the risk appetite of the accountable institution. Okay, so these are generally considered to be the risk factors that you can use when you are conducting a risk assessment and a risk rating framework. So as I mentioned a little bit earlier, there is a client level risk assessment and there is a business level risk assessment. The business level one will be going into a bit more detail within the next few slides. So products and services, that's specifically with regards to the products and services that the accountable institution provides. So do you accept third-party payments? Do you accept cash payments? Are they mostly EFT? Do transactions or services involve the cross-border flow of money? And what is the general duration or relationship of that specific transaction? Okay, so delivery channels, is it a direct relationship with their client? Or is it working through an intermediary? And do they have you met them face to face? Do they walk into your offices, or is it non-face to face? I think it's generally safe to say there won't be as much non-face to face for legal practitioners. For example, you would see with crypto asset service providers, you can open up an account with taking a selfie and scanning a copy of your ID and sending it through to the accountable institution. That most likely does not happen as much for law firms, but ultimately that does need to be taken into consideration, especially with the technology constantly evolving ultimately. So geographic area, is the transaction going to be concluded in South Africa, or is it in a foreign jurisdiction? Is it concluded in high-risk countries? And if the client is based somewhere else, is there an element of client confidentiality in a foreign jurisdiction? So for example, with regards to tax havens, so if one were to read the Panama Papers or the Paradise Papers, not that it's required reading, as we received questions about that in previous webinars, but ultimately, if one were to read on the media, and there's quite often been information leaks with regards to foreign politically exposed persons essentially laundering their proceeds through those tax havens and only being found out once it's been leaked to the public. So you would just need to keep in mind, if your client is based in that foreign jurisdiction, what are their confidentiality laws in that regard? And hand in hand with that, are they susceptible to weak regulatory oversight? So client type, one could argue, is the most important risk factor, as ultimately the clients, when they are concluding a transaction with you, when they're entering a business relationship with you, they are the one they are the party that is ultimately introducing the money laundering risk and terrorist financing risk. So that's pretty much why you can see here why the client type is the longest risk factor. It's the most significant one. So the client, is it a natural person? Is it a legal person? If it is a legal person, is it subject to complex structures with lots of corporate layering? Are they politically exposed? So politically exposed being a PEP, so a domestic PEP or a foreign PEP, politically exposed person. And is the prominence of the person, are they a prominent businessman, for example? Adverse information and negative media. If you have come across their name on the internet and there has been rumors about them or negative information that has been leaked about previous transactions that they have been involved in, previous businesses, for example. And similarly, have there been money laundering findings, or are there possible criminal records and that sort of thing? And what would be the transactional pattern of the client? So just to touch upon the adverse information, negative media, and money laundering findings. So it's not expected for accountable institutions to become like private investigators. That's not the purpose of highlighting this information. It's just if one were to do a search as you are determining if they are politically exposed, for example, if you were to use common internet search engines and there is adverse media in that regard. So you would not need to pay for a service to do so, for example. That's not expected of you, as there shouldn't be a cost involved, but it's just if information comes to light that will impact upon the risk assessment. Then lastly, other factors. What is the institution's approach to money laundering? Have you had sanctions in the past? What is your strategy? And regulatory fines in similar industries and learnings typologies, that being trends that have emerged. An example of that would be, so there's FATF guidance with regards to legal practitioners, and the FIC, we've published a sector risk assessment with regards to legal practitioners, which should hopefully, so there's a section that provides some light with regards to risk indicators, for example. So if a risk indicator presents itself during the business relationship that you have with the client, you might want to possibly think about submitting a suspicious and unusual transaction report. But I'll be discussing the reports a bit later as well. Okay, so a risk matrix at a client level. So generally you would associate higher scores with a higher risk, medium risk being in between, and low risk being a lower score. And you should risk rate at onboarding and ongoing due diligence stages. So this is just an example of a risk matrix. Please do take a look at PCC Public Compliance Communication number 53, as there's a template with regards to a risk matrix that you can use. And we specifically tailored it to DNFBP's designated non-financial businesses and professions. So please do take a look at that. You can use that as a template, and then you would just plug in the information with regards to that specific client and update the risk matrix for that transaction. And then you'd be able to get an overall rating, which would impact upon the level of customer due diligence levels that you would use for that specific client. So just to elaborate on this example, so it's a natural person, litigation is criminal law, the geographic area is in Gauteng, it's face-to-face, but the customer is unemployed. So if they are unemployed, then that is possible higher score with regards to the risk involved. So this would be a medium risk. So on the other hand, this second customer is a legal entity, which is generally a higher risk, as there is a higher possibility of money laundering, terrorist financing, proliferation financing. not to say that it's a certainty that they are possibly conducting such activity, but there is a risk involved that they are. So similarly, conveyancing, higher risk as well. It's in South Africa, face-to-face, so same risk involved, and it's in technology. So as a result, similar sort of situations or similar risk factors, should I rather say, but this one is higher risk when one adds up all the different scores. So these are just examples. Of course, you can use your own risk scores ultimately. Okay, so just to touch upon certain elements of customer due diligence. So accountable institutions may not conclude business with an anonymous client or a client with apparent false or fictitious name. So you need to obtain and record client information in terms of Section 20A of the FIC Act. So apparently false or fictitious, that would just be in terms of you look at this name and you can tell almost immediately that it is false or fictitious. So, for example, if the name is Mickey Mouse, for example. Okay, so single transaction where the amount is more than 5,000 Rand. It's concluded on a once-off basis, so no expectation that it will occur again, and you would need to still identify and verify your clients. So if it's a single transaction, if it is a business relationship, you would still need to identify and verify. Single transaction being more than 5,000 Rand. So accountable institutions must identify all prospective clients, identify all persons authorized to act on behalf of clients, and verify identities. So we specifically differentiate between identify and verify, as you identify the client, excuse me, by requesting specific documentation from the client. I'm being quite broad because the FIC, we don't like to prescribe which documentation you would request from the client, but you would probably much be pretty safe with requesting a copy of their ID documents, and then you can decide which other documents you need to identify the client. But ultimately, you identify the client, and then based on that information, you would verify if the client is who they say they are by using an independent third-party source. Okay, so, and it would need to be in line with the accountable institutions, risk management, and compliance program. Okay, so beneficial ownership requirements. So there's certain extra sections in place with regards to legal persons, trusts, and partnerships. So this section of the Act was specifically amended with regards to the General Laws Amendment Act, so that we could reflect more the international standards with regards to the beneficial owner, and just to line up the legislation with regards to, for example, the Companies Act. Okay, so the FIC Act defines beneficial owner as a natural person or who directly or indirectly ultimately owns or exercises effective control of a client, of an accountable institution, or of a legal person, trust, or partnership that owns or exercises effective control. So as you can see here, it mentions control quite a few times. And of course, there are specific persons that need to be identified in terms of that section. So effective control does have a certain meaning. We'll just be discussing that in a bit more detail now, and we'll be discussing the method to determine that information. Okay, so with regards to the requirements, so the nature of the business, the ownership and control structure. So accountable institutions should understand the different types, forms, and basic features of legal persons, trusts, or partnerships onboarded as their clients or potential clients, the manner in which legal persons, trusts, or partnerships are created, and how to obtain beneficial ownership information per client type, how to determine the possible types of beneficial owners each client type should have, and how to identify money laundering, terrorist financing, and proliferation financing posed by each type of client. So specifically with regards to the last one, I do believe this sector is quite fortunate in that you would most likely know the manner in which legal persons, trusts, or partnerships are created, as that is within the realms of the profession. But with regards to identifying money laundering, terrorist financing, and proliferation financing risk as posed by each type of client, please do take a look at the sector risk assessments that are on the FIC website. That would certainly be of assistance here. Okay, so the process of elimination. So you need to identify each natural person who has controlling ownership interest in the legal person. So for example, shareholding, particularly with regards to private companies where there's only a certain number of shares that are within the whole company. And then if that first step doesn't work, so you can't determine who the person is that has controlling ownership interest, then you would identify each natural person who exercises control over that legal person through other means. So example, a proxy. And then lastly, identify each natural person who exercises control over the management of that legal person. So the managers that are involved in the institution or the directors at the end of the day. So if step 1 doesn't work, then you drill down to step 2, then you drill down to step 3. Okay, so please do take a look at draft public compliance communication 121. So the comments were due in 8 December 2023 and provides guidance on beneficial ownership obligations. And there's also the elements of risks and red flags. So as the 2 previous slides ago had mentioned, understand the money laundering, terrorist financing, and proliferation financing risks associated with each type of legal person, trust, or partnerships. Please do take a look at Public Compliance Communication 121, as can be found on the FIC website. Okay, so can imagine it's quite a lot of information at this stage. So for beneficial ownership, please do take a look at PCC number 121, and that's for legal persons, trusts, and partnerships. Okay, so politically exposed persons, prominent influential persons. So this is also one of the elements of client risk that is associated with a specific customer. Okay, so what is a PEP? A PEP is a person who holds or has held a prominent public function and has some level of influence and control over public funds, benefits, and decision-making powers. And the abuse of the role could result in corruption and bribery. So ultimately, if they have a prominent government function and they have specific elements of influence and control over those funds and decision-making powers at the end of the day. So please do take a look at Schedule 3A, 3B, and 3C. So these different schedules, they actually have the specific roles, the specific titles that PEPs would have. So it wouldn't be, so we sometimes get a question asking if the person works, for example, in the SANDF, if they are specific, if they would be considered to be a PEP, and they would actually need to be, for example, a general at the end of the day. So it wouldn't be somebody who is just an employee in a department or a department of finance, for example. They would need to be the director of finance. So it wouldn't be, it's not a blanket approach. It would need to be specific people that have specific titles in those departments or ministries with the government. So foreign PEP, domestic PEP is treated slightly differently, and politically influential person was added with the FIC Act being amended by the General Laws Amendment Act as well. So that is a further category of politically exposed persons. Okay, so accountable institutions must determine whether a prospective client, existing client, beneficial owner of the client, or person acting on behalf of the client are PEPs or PIPs, or immediate family members or known close associates. So accountable institutions would be required to conduct additional due diligence when dealing with PEPs or PIPs and understand the money laundering risk associated with dealing with PEPs and PIPs. And do keep in mind, foreign PEPs are considered to be high risk. So they are automatically considered to be high risk. Domestic PEPs, you would be able to conduct a risk assessment, and if they are high risk, then the statutory requirements in terms of Section 21 G of the FIC Act, then ultimately that would come into play. But with regards to foreign PEPs, if the foreign PEP wishes to conduct a business transaction with you, a business relationship, there is a risk that they are possibly laundering foreign proceeds. And it's not to say that this is just South Africa's view. This is globally, it's been globally determined, globally accepted that foreign PEPs are generally more vulnerable to money laundering, terrorist financing, and proliferation financing. Okay, so I mentioned there are specific requirements that are in place. So for foreign PEPs, these 3 requirements always need to take place. So you need to obtain senior management approval to establish a business relationship. You need to establish their source of wealth, and you need to implement enhanced due diligence monitoring. So source of wealth, where does their money come from? To provide an oversimplification. So the source of funds is where's the money for that specific transaction. Source of wealth, you would need to determine where the money behind them comes from, ultimately. So for foreign politically exposed persons, these 3 requirements are in place, and for domestic politically exposed persons and for politically influential persons, if they are determined to be high risk, then these 3 requirements are triggered. I believe I didn't discuss what a politically influential person is. So these are businesses that conclude transactions with local organs of state. So, for example, tenderpreneurs at the end of the day. Okay, so transaction monitoring. Oh, actually, just one last thing to finalize with regards to this topic. So please do keep in mind that each customer does need to be scrutinized in this regard. And as I mentioned a little bit earlier with regards to adverse media, then ultimately you would just be able to do so by using the internet. Please do take a look at Public Compliance Communication number 51. We sometimes get questions asking if you would need to use specific businesses that provide screening. You do not necessarily have to. You would theoretically be able to do so using the internet, and there are also links that can be found in PCC 51, which is for PEPs at the end of the day. But some of the terminology has changed with regards to the amendments, but the principles that's inside of PCC 51 is still applicable. Okay, so transaction monitoring. An accountable institution must monitor transactions, establish the source of funds to ensure that this is consistent with the client's business and risk profile, and establish the background and purpose of all complex transactions. So source of funds, that being the money involved for that specific transaction. So, for example, if the customer is unemployed, but they are able to provide you with significant sums of money, there's a possibility that they are acting as a money mule, for example. So for establishing the background and purpose of all complex transactions, so that would be based on your knowledge of the industry. So a common example would be if a client who was recently introduced to you, for example, deposits 10 million rand and then asks for a refund of that money, saying, "Oh, my apologies, that was paid to you by mistake," then that could possibly be a method of laundering those funds. So that's just an example. But ultimately, complex transactions that would be based on your knowledge of the industry. And particularly if there's lots of small transactions, for example, large, small payments are being paid into your trust account and expecting for the transaction to be concluded very quickly, then you might want to consider the background and purpose of all of that taking place. And ultimately, the purpose of this is for accountable institutions to submit suspicious and unusual transaction reports to the FIC, as there is a possibility that the customer is attempting to conduct money laundering, terrorist financing, and or proliferation financing. Okay, so doubts about veracity, doubts about the authenticity ultimately. So where an accountable institution doubts the veracity or adequacy of previously obtained information, the accountable institution must repeat the identification and verification steps. So for example, if you receive a copy of the client's ID and the email, and the name that they use when they sign off an email from them is completely different to that ID document that they provide, or any other example where you're just wondering if they are maybe being untruthful about the information they provided, or if when you're doing a verification and of the customer's ID and there's no match, for example. So ultimately, you would just need to repeat the identification and verification steps. Okay, so record keeping. So I mentioned it at the beginning of my section of today's presentation. So accountable institution must keep records of client information and transaction information, the business relationship, and reports submitted to the FIC. So specifically with regards to reports, please do keep in mind, once you've sent a report to the FIC and it has been processed, you can access it on your dashboard for a certain period of time. And please do not ask the FIC for previously submitted reports, as we wouldn't be able to provide that information. Similarly, we've sometimes received requests from auditors asking for the clients' reports they've submitted or a third party's reports that they've submitted, and we would definitely not be in a position to provide that information. Okay, so lastly, the client, 5 years from the date of the termination of the relationship, conclusion of the transaction, and or submission of the report. So please do keep in mind electronic and hard copies, either or, they're pretty much treated the same. And an accountable institution can make use of third-party storage providers, but please do inform the FIC in writing of the third-party storage provider, and needs to be accessible by both yourselves and the regulatory bodies, and needs to be kept safe. And there's specific regulations in that regard, which provides that specific information. I believe it's regulation 22A. So please do send us a compliance query in writing of the third-party storage provider that you wish to use, or you can send us a or you can send it to us in the post. Okay, so reporting. So where the previous compliance obligations, I can understand this is a lot of information, but the reporting is also incredibly important for the FIC, as ultimately that is how the FIC gathers financial intelligence to ultimately pass that on to law enforcement agencies when they investigate crimes. Okay, so there are several different reports that are applicable in terms of the FIC Act. So there's a cash threshold report, terrorist property report, suspicious and unusual transaction report, and lastly, an international funds transfer report. So IFTR, that is a cross-border money movement report, and as my colleague Ashley mentioned a little bit earlier, it's only for very specific authorized entities, and we don't want to overburden you guys with too much information, so we're not really going to go into too much detail with regards to an IFTR, but it's pretty much financial services providers, banks, for example, and they have specific licenses from the South African Reserve Bank and that sort of thing. So it's not really applicable to your sector, your schedule item. Okay, so with regards to a cash threshold report, so in terms of Section 28 of the FIC Act, and it's triggered by cash transactions that are above the threshold of 49,999 Rand and 99 cents. So as you can see here, the threshold was increased within the last couple of years, as ultimately the previous threshold was maybe perhaps a little bit low. So ultimately, once the transaction has gone above that amount, you would submit a report to the FIC. And please do keep in mind, aggregation is no longer applicable. So there used to be an option for institutions to submit a CTRA, cash threshold aggregation report, or cash threshold aggregate report, sorry. But ultimately, please do not submit that to the FIC anymore, as it will ultimately get rejected and you would just be wasting your own time. So for links, for funds for a linked transaction, you do not need to submit that anymore. So cash has a specific meaning in terms of the FIC Act, and please do take a look at Guidance Note 5C with regards to cash threshold reports as well. So it's with regards to cash, coins, paper money, and traveler's checks. So it's not with regards to EFT, electronic fund transfers. So if you receive cash at your premises, if you pay cash to the client, then you would submit a report to the FIC. And similarly, if you receive a bank deposit into your account, then you would submit a report to the FIC. Okay, so you need to report within 3 business days of the transactions. So it would be considered to be good practice just that you monitor your bank accounts daily to identify if cash has been deposited into your bank account. So there is a scenario where you would submit both a CTR and an STR, STR being a suspicious and unusual transaction report, and that is where your client is attempting to send you a series of cash payments in small amounts to avoid the threshold of 49,999 Rand being triggered and a report being sent to the FIC. So if you realize they are attempting to avoid detection, attempting to avoid the reports of the CTR taking place, then you would need to submit both an STR to the FIC and a CTR as well. Okay, so with regards to regulatory reports, please do keep in mind reports need to be submitted on GoAML, and you need to select the specific report type. So if 2 reports are triggered, if the transactions, should rather say the circumstances arise, and you need to submit more than 1 report, please do keep in mind you would need to submit multiple reports. That's why we say dual reporting is mandatory. So we do suggest you take a look at the message board just to make sure that the report is processed and it's not rejected. So if you have a rejected report, you need to remediate that, and reports that are not submitted or that are in drafts are considered to not be reported. Okay, so just to focus on suspicious and unusual transaction reports. So I've mentioned a couple of times throughout today, as arguably it's perhaps the most important report at the end of, ultimately, as that is how the FIC builds financial intelligence with regards to potential crimes that are taking place. So that is why we discuss STRs as much as possible and frequently as possible. And based on that financial intelligence, we provide it to law enforcement agencies or provide that information to foreign jurisdictions, for example, to assist with regards to international cooperation. Okay, so when filing STRs, SARs, TFTRs, and TFARs, the suspicion or knowledge relates to the proceeds of unlawful activity itself, facilitating the transfer of proceeds of unlawful activity, has no apparent business or lawful purpose. So specifically with regards to no apparent business or lawful purpose, so that would be based on your knowledge of your sector, of your industry. If in your subjective mind, the client's transaction patterns or the client's behavior is a little bit irrational, is a little bit strange, is a little bit suspicious, then ultimately you can submit an STR to the FIC. So as you can tell from my wording, it is subjective at the end of the day. So if a suspicion is formed, or if you have knowledge of that suspicious activity, then you should submit a report to the FIC. So if there's an element of tax evasion or attempted tax evasion, an offense relating to the financing of terrorist and related activities, contravention of a prohibition under Section 26B of the FIC Act. So Section 26B is with regards to targeted financial sanctions, and we're going to be touching upon that a little bit later again. Then lastly, any structuring of a transaction or activity which is conducted for the purpose of avoiding giving rise to a reporting duty under the FIC Act. So an example of that would be sanctions evasion. So if a customer is acting on behalf of somebody else and that other person is listed on the targeted financial sanctions list. Sorry about that. Looks like that's piece of that slide. My apologies. Okay, so please do keep in mind there is no monetary threshold that is applicable for the reporting of suspicious and unusual transactions. So there's no floor and there's no ceiling in that regard. So the transaction amount does not matter. So an STR will be submitted to the FIC when it is with regards to a complete transaction or a series of transactions that relates to suspicion or knowledge of the proceeds of unlawful activity. So that is different to an SAR, a suspicious activity report, where that involves an incomplete transaction. And by incomplete, we mean interrupted, aborted, abandoned, and at the end of the day, not concluded. So, for example, if you request identification documentation from the client and they provide you with a copy of their driver's license, but it has expired, for example. So you ask for a copy of their ID and they pretty much break contact with you. That could be an example of submitting a suspicious activity report. But that is just an example. Of course, it would be dependent on the specific circumstances. Okay, so inability to conduct customer due diligence. So an accountable institution must consider submitting a Section 29 report to the FIC if they are unable to establish and verify the identity of the client and or other relevant persons in terms of the risk management and compliance program, or obtain information about the business relationship with the client, or conduct ongoing due diligence. So if you're unable to conduct customer due diligence, then you should consider submitting a Section 29 report to the FIC. Section 29 reports being suspicious, unusual transaction reporting, or suspicious, unusual activity reports. Okay, so with regards to time periods, you should submit a report to the FIC as soon as possible after you have become aware of the facts which gave rise to the suspicion, and it cannot be longer than 15 days, ultimately being 15 business days. Okay, so what are the implications of filing a Section 29 report? We quite often receive questions with regards to whether an accountable institution can continue transacting with a customer. And the short answer is ultimately, yes, you can. You can continue with the transaction unless the FIC informs you in writing not to proceed with the transaction. But that is governed with regards to specific section of the FIC Act, that being Section 34, and we would need to direct you in writing that you cannot proceed, and it would be limited to the amount of 10 days. And lastly, do keep in mind with regards to tipping off, the person submitting the report cannot inform anyone, that being the customer and or anyone in the general public, that a report was submitted or the contents of that report. So please do keep in mind tipping off is an offense in terms of the FIC Act. Okay, excuse me one moment. Sorry about that. Okay, and then the last report, terrorist property reporting, in terms of section 28A, an accountable institution which has in its possession or under its control property that is owned or controlled by, on behalf of, or at the direction of a terrorist and or a sanctioned person must within 5 days of becoming aware of that information report that fact and the prescribed particulars to the FIC, and that property must be frozen. So that means you cannot proceed with the transactions with this client. So this was just mentioned here as it is one of the types of reports, but we will be discussing terrorist property reporting under targeted financial sanctions. But a sanctioned person is ultimately a person who is listed on the targeted financial sanctions list. Okay, so an accountable institution must scrutinize client's information to determine whether such person is a terrorist and or a sanctioned person. And you must be able to identify those sanctioned individuals. So you need to do it during the client's take-on process, when new lists are adopted and published, and during the transactions. Okay, so ultimately, you need to scrutinize your client's information with regards to whether they are a politically exposed person and whether they are a designated or a sanctioned person. Okay, so we are now going to speak about targeted financial sanctions. So in a nutshell, step 1, you need to scrutinize or screen your client against the targeted financial sanctions list on the FIC website. Step 2, if there's no hit, you continue with the transaction as you normally would. And then step 3, if there is a hit, if there's a match being a direct match, you need to freeze and report that information to the FIC. Okay, so this is just a breakdown of the specific obligations. So section 26A sets out the targeted financial sanctions regime and with regards to the UN Security Council resolutions. So it includes terrorist financing, proliferation financing, and crimes against humanity. And it's automatically adopted in the South African framework without once it is issued. So it is without delay. So without delay has a specific meaning. I'll be touching upon that at the end of this presentation. So just to be clear, the targeted financial sanctions list can be found on the FIC website, and it is a consolidated list of all the United Nations Security Council resolutions. Okay, so section 26B sets out the prohibitions with relation to acquisition, collection, use, control, providing or making available any form of property, being financial or other services or economic support to a listed person. So as you can see here, property, financial property, of course, can be movable property or immovable property. So it applies both directly, indirectly, in whole or in part, or by other means. Apologies, I see there's a spelling mistake there. So section 26C of the FIC website, section 26C of the FIC Act, sets out permissible financial services, and the minister must provide explicit consent in writing. So that would be with regards to very specific circumstances, and you would need to follow a specific process in that regard. And it's limited to specific services. Okay, so section 28A requires a terrorist property report to be submitted when a client is on the TFS list, and it's referred to as property possession or under your control. And you would need to scrutinize your clients and potential clients' information against the targeted financial sanctions list. Okay, so where you scrutinize information concerning a client, so the director of the FIC gives notice of persons, entities who've been designated as sanctioned persons or entities in a resolution of the UNC, which we refer to as the TFS list. So it's natural persons or entities that are designated by the UNC, and it's ultimately they're involved in terrorist acts and or are connected to proliferation of weapons of mass destruction. So section 28A3 of the FIC Act requires institutions to scrutinize the information concerning clients with whom you have a potential business relationship against the TFS list. And you would need to scrutinize that information regardless of the risk involved. Excuse me. So a heightened terrorist financing or proliferation financing risk, an accountable institution should perform enhanced scrutiny of clients' information. So ultimately, if they are a designated person, which in all honesty doesn't happen very often, but if they are a designated person, you should consider that that would be a heightened terrorist financing and proliferation financing risk. And of course, if you are a designated person in terms of the targeted financial sanctions list, that would be as a result of terrorist activity and or crimes against humanity. So it would be very specific people that would be placed on this list. So information concerning a client is with regards to ultimately you would need as much information as possible, as the TFS list is global in scope. So it should be the person's name, identification number, place of birth, address, date of birth, nationality, and for legal persons, the entity's name and or any other information. And if you do have the country of residence, it would be suggested that you use that for the natural person. So ultimately, it is international in scope. So it quite often happens that if the person has a commonly used first name, for example, then there could be a result of a country in Europe having a person who has a similar name. So that's why we say it needs to have as much information as possible. As many fields need to be completed as possible. But I'll show you a screenshot of the fields that I'm referring to. Okay, so we recommend that all persons or entities that are required to have approval to deal in controlled goods or activities, concerns of proliferation financing, should scrutinize the client's information against the TFS lists as a control to mitigate any risk of proliferation financing or weapons of mass destruction. So you should not process transactions where you're unable to determine accurately whether the transactions will breach TFS obligations. You need to make sure that the latest TFS list is used, either through manual or automatic screening. So some accountable institutions used to print the TFS list and then just tick against their client's name to make sure that it's not present. But ultimately, if it's a printed list, it can go out of date. So ultimately, I would just suggest that you use the TFS list that's on the FIC website, and it's updated on a daily basis. Okay, so where you are to freeze property linked to a designated person or terrorist proliferation financing activity. So in terms of Section 26B of the FIC Act and Section 4. So ultimately, that is a bit of a mouthful there, but you cannot process any of the information, any of the property that is considered to be terrorist activity or linked to terrorist activity. So if you identify a designated person or entity, they must immediately freeze without delay any activity, must freeze the property that is involved in a transaction, and you cannot proceed with the transaction. Ultimately, it is an automatic obligation to freeze. So you do not need to obtain consent from the FIC, and there's no need for a court order in that regard. And your RMCP should provide for the process of doing so. So it applies to all property being movable or immovable, and all services provided to a designated person. And proceeds would, property would include funds at the end of the day. Okay, so Section 26C of the FIC Act, an accountable institution may proceed, provide, or release property to designated persons once they have been given written permission for such release from the Minister of Finance. But ultimately, there's a specific process that needs to be followed, and it's for limited services, pretty much, for example, to purchase groceries and that sort of thing. Okay, so how you would access the TFS list. So you go to www.fic.gov.za. You would click on the Home tab. So as you can see here, it's on the left-hand side in the middle of the screen. And the tab should drop down, and you will be able to select the targeted financial sanctions option on the website. Okay, so this is the page that loads, and we would suggest that you subscribe to the automated notification email if you haven't received emails in that regard. So accountable institutions must screen against the TFS list, freeze assets, and report of the designation or the match on the TFS list. Okay, so this is the fields that are required to be completed. As you can see here, you can search against the person or the entity if a legal person is your client. So ultimately, it is suggested that you complete as much information as possible. As I mentioned a little bit earlier, it is international in scope. So please do keep in mind, the more information you can provide here, the less likely that there will be a false positive. So please do take a look at PCC 44A. So that was issued on the 29th of February this year and provides guidance on the implementation of the targeted financial sanctions. And also highlights the risk-based approach to combating terrorist financing and/or proliferation financing. And of course, PCC 44A, that can be found on the FIC website, and there should be a link in this presentation as well. Okay, so with regards to the freezing of property of designated persons and/or entities, so there are 3 freezing obligations. So there's the automatic one, which I covered a little bit earlier in terms of Section 26B of the FIC Act, the automatic obligation to freeze in terms of Section 4 of POCTATARA, and an ex parte obligation to freeze in terms of Section 23 of POCTATARA. Okay, so 26B, I believe, yeah, we might be running a little bit light on time, so I'm just going to pretty much skip that for now, as we've pretty much discussed that a little bit earlier. Okay, so it's with regards to a client, person acting on behalf of a client, on behalf of another person, and beneficial owner, and a party to a client's transaction, including a person who might benefit from that transaction. Okay, so it's can be property or monetary, and you would need to immediately seize any activity. It needs to be done without delay. Sorry about that. Okay, and then in terms of Section 4 of POCTATARA, so similar to Section 26B, Section 4 has the effect that when an accountable institution identifies a designated person or entity or terrorist-related activity, the accountable institution must immediately seize that activity in relation to that designated person or entity or activity. Okay, and then Section 23 of POCTATARA with regards to an ex parte application. So you would seize the activity and you cannot release that as well. Okay, so with regards to automatic obligation to freeze, you do not need consent from the FIC, and there's no need for a court order, and your risk management and compliance program must provide for the process of freezing that property. Okay, so please do keep in mind that without delay is within a matter of hours and would be on having reasonable grounds or reasonable basis to suspect or believe that a person or entity is a terrorist, one who finances terrorism, or a terrorist organization. So it's in the context of the need to prevent the flight or dissipation of funds or other assets that are linked to terrorists, terrorist organizations, those who finance terrorism, and the financing, proliferation of weapons of mass destruction, and the need for global concerted action to interdict and disrupt their flow swiftly. So ultimately, if you control property that might be used, the proceeds that might be used for terrorist activity, ultimately that's the whole principle behind the freezing of that property, so that the proceeds do not reach their intended target destination so that terrorist activity can be carried out. So that is why the freezing takes place. And it's usually under a specific time frame. Okay, so that is pretty much me from my side, but these are some links that can be found on the FIC website. So the reference guide for accountable institution, that's with regards to specific compliance obligations that accountable institutions are subject to. So please do take a look at that. PCC 47A, that is the guidance specifically applicable to yourselves. PCC 53, so that's Risk Management and Compliance Program. As I mentioned a little bit earlier, there's a client risk assessment, a risk matrix that you can use as a template to build your own risk assessment tool. And of course, at the end of that document, there's also a template of an RMCP, which specifically focuses on an RMCP for a designated non-financial business and profession. So please do take a look at that annexure. You can use that as a template for drafting your own RMCP if you don't have an RMCP in place. If you do, you can always take a look at it and compare the two to each other to see whether you possibly have gaps in your RMCP. So Guidance Note 7, that is a great document for introducing accountable institutions to risk and customer due diligence, and it has several different topics in that regard. Targeted Financial Sanctions Manual, that is pretty much a document that you can use to help you with the process of how to conduct targeted financial sanctions, how to scrutinize your clients against a targeted financial sanctions list. And PCC 44A is the guidance for the implementation of targeted financial sanctions. And then lastly, with regards to beneficial ownership, please do take a look at PCC 121. Okay, so if you do want to contact the FIC, please call us on 012-641-6000, select option 1, or you can submit a compliance query on the FIC website. FIC website being www.fic.gov.za, and you will click on contact and click on the compliance query option. Okay, oopsie. So yes, thank you for your time this morning.
Thank you so much, Michael. What an informative session. I want to believe that we have all learned a lot from what you guys have presented. On this moment, looking at the time, may I now call Mr. Alfred Horner from the LPC to also take us through a brief presentation regarding the role of the legal practitioners. Thank you, Alfred.
Thank you, Thabo, and good morning to everyone once again, and thank you for taking the time from your busy schedule to join us in this important session. The purpose of this session is for all of us to engage on all aspects concerning our respective obligations in terms of the FICA Act, so that we take the necessary steps and put measures in place to remove, as it has already been stated, remove the country from the grey list on which it was placed by the Financial Action Task Force in 2023. In my short presentation, I will be covering 3 topics, these being the role of the LPC in terms of the FICA Act. Can you move to the next slide, please? In terms of the FICA Act, offenses under the FICA Act, and I shall in the process also indicate how does the contraventions in terms of the FICA Act come to the attention of the LPC.
Sorry, Alfred, may I please ask Kabelo to assist with the presentation slides?
Yes, please.
Kabelo?
Can you see it now?
Yeah, please move to the next, Kabza.
Okay. There we go.
Next slide, please.
Can you see it?
I'm still on slide 1, but I can continue with the presentation if we are having technical issues.
I think there's a slight delay. On my side it's on the third slide.
Okay, let me then continue because I know the content of the slide.
Sorry, Alfred. Kabelo, please just stop sharing and then share again. Maybe see if we can't move those slides. Because now Alfred won't be able to do his presentation. I think you can move back to slide number 2. Yeah, I think now it's fine. Yeah.
Yeah, as I've indicated in my short presentation, I will be covering the role of the LPC in terms of the FICA Act, offences under the FICA Act, and I shall indicate in the process how does the FICA Act contraventions come to the attention of the LPC. The next slide, please. The LPC, which is the Legal Practice Council, as we all know, regulates all legal practitioners and aspirant legal practitioners in South Africa. Legal practitioners are accountable institutions in terms of the FICA Act. As such, they are required to comply with the obligations as set out in the FICA Act. The role of the LPC is to ensure that legal practitioners, as accountable institutions, comply with their obligations as set out in the FICA Act. Hence, there is a provision in the Code of Conduct for Legal Practitioners, candidate legal practitioners and juristic entities, which was published in terms of Section 36(1) of the Legal Practice Act 28 of 2014. Clause 18.17 of the Code requires of a legal practitioner to take all such steps as may be necessary from time to time to ensure compliance at all times as an accountable institution with the requirements of the FICA Act. Furthermore, in terms of Clause 21 of the Code, the contravention of any provision of the Code, in this instance being Clause 18.17, is a misconduct subject to the disciplinary processes of the LPC as set out in the Legal Practice Act and the rules promulgated in terms thereof. What this means is that in addition to any penalties that might be imposed by the Financial Intelligence Center Act, a legal practitioner found guilty of having failed to comply with the obligations set out in the FICA Act could face additional sanctions imposed in terms of the Legal Practice Act, read with the rules after investigation by the independent disciplinary committees of the LPC. It is for this reason that the LPC, together with the Financial Intelligence Center, decided to have this session to alert legal practitioners of their obligations under the Financial Intelligence Center Act, as well as the consequences of failure to comply, and also to address any questions or uncertainties that legal practitioners might have. Next slide, please. Next slide, Councillor. Thank you. The offences are identified in terms of the Financial Intelligence Center Act. I think these have already been covered by colleagues from the Financial Intelligence Center, being Michael and Ashley. One will be the failure to register with the Financial Intelligence Center as required in terms of Section 43, capital B of the FICA Act. As it has already been stated, on successful registration, the Financial Intelligence Center will issue a number confirming registration. It is important to keep a record of or a proof of registration in the file. We urge legal practitioners who have not registered yet to do so as soon as possible. The second offense would be the failure to identify and to verify clients as required in terms of Section 21 of the Financial Intelligence Center Act. As Michael has indicated, this requires legal practitioners to ensure that they have in each of their clients' files the details of the clients, being the full names, identity numbers, residential addresses, and where applicable, the business addresses, registered address, registration number, the person's authority to establish a personal relationship where the client is a juristic entity or a trust. These are some of the examples. The supporting documentation which may be needed to be in the file will include a copy of the client's identity document, utility bill, and any resolution where applicable. And once again, it is important to keep a record of these documents. And the third one would be the failure to report to FIC cash receipts which exceeds the prescribed limit as required in terms of Section 28 of the FIC Act. Michael has already adequately covered that point and indicated the amount. And the next offense would be the failure to report suspicious and unusual transaction to the FIC as required in terms of Section 29 of the Act. And the last one, among the other, would be the failure to develop and to submit to the FIC a risk management and compliance management program as required in terms of Section 42 of the FIC Act. As Mike has indicated, a precedent RMCP, which can be used only as a guide, is available on the FIC website, and we as the LPC, we did circulate it to all legal practitioners for their information to use it as a guide when preparing their own RMCP. Now, how does the contravention come to the attention of the LPC? Firstly, the LPC and the Financial Intelligence Center, together with the supervisory bodies of the other sectors or industries, meet regularly to discuss issues of compliance by all accountable institutions. For instance, the legal practitioners would have noticed that recently the LPC has effected an amendment in the provisions of Rule 17, which deals with the requirements of admission, to include the requirement of an independent criminal verification in order to enter the market or as a market entry requirement. This was as a result of the discussions of our discussions with the Financial Intelligence Center. Secondly, in terms of Section 45B of the FIC Act, the FIC is empowered to conduct inspections in order to assess the level of compliance with the provisions of the FIC Act by accountable institutions. These inspection reports conducted by FIC can be shared with the LPC. In that regard, I think it is important that we urge legal practitioners to cooperate with the investigators appointed by FIC and to allow them access to any information that they may require in order to perform this function. In addition to the inspection conducted by the FIC, the LPC as well as the Legal Practitioners Fidelity Fund are empowered in terms of Section 87 of the LPA to conduct an inspection of the records of legal practitioners, also to establish the level of compliance. And lastly, legal practitioners are required to submit trust account audit reports in terms of Rule 54 of the rules promulgated in terms of the Legal Practice Act. The LPC received trust account audit reports prepared by an auditor. As part of this process, the auditor is required to also provide information pertaining to the legal practitioner's compliance with the FIC Act. If there is any non-compliance with the provision of the FIC Act, the auditor will qualify the report. In the circumstances, we urge legal practitioners to have regard to the provisions of the Act and to understand their obligations. And in the case of uncertainty or should they have questions, not to contact us as the LPC at the provincial level or nationally or even the FIC directly. There are also guidance notes which are issued by the FIC, which are published on the LPC website. I think that is my short presentation. And again, I thank you for your attendance, and we shall be able to take any questions that may come. Thank you so much.
Thank you so much, Alfred. I think the presentation also was very informative and relevant and aligned to the requirements of the FICA Act. So at this point, Kabelo, if you may please come through to facilitate the question and answer sessions as posted in the chat. Kabelo.
Thank you, Thabo. I wanted to also just get your guidance. We had scheduled the time between 10 and 12. Would you prefer that I quickly read the question, or would it be better that we maybe do a written Q&A? I'm not sure if you could perhaps give me guidance.
We can do a written Q&A that we can also publish to the just to save the time.
Okay. I think then, yeah, noting that we had scheduled the session between 10 and 12, we can circulate then the responses to the chats in writing sometime next week. What we will do is that a copy of the recording plus the presentation plus the responses to the Q&A will be provided. I think then we can leave it there. So back to you, Thabo, to conclude the session. Thank you.
Yeah, thank you so much, Kabelo. And everyone present, I would like to relay a special message and acknowledgement as well as the gratitude from our Chief Executive Officer, who was also in attendance in this session. She really appreciated the content of the presentations from FIC, and she feels this is very relevant to the legal practitioners as the regulator. As such, these engagements will be ongoing going forward and will ensure that practitioners are brought to attention of whatever developments that FIC is dealing with. And this is not a once-off awareness session, as I have indicated, it's ongoing. I don't know if there are any closing words from the FIC before we formally close off the session. Michael, Ashley?
Oh, perfect. Thank you so much. Yes, unfortunately, Ashley had a calendar conflict, so she had to leave a little bit early. But just from my side, please do check out the FIC website where it comes to targeted financial sanctions and the guidance, the links for which will also be in the presentation. And please do not hesitate to submit a compliance query on the FIC website should you have any questions or wish for an elaboration. But as you mentioned, we will also provide written responses in that regard. Thank you very much for your time.
Thank you, Michael. And on that note, let me thank everyone for your attendance. And we have come to the end of the session. Enjoy the rest of your day, please. And we will further communicate any other sessions that have been planned between the FIC and the LPC. Thank you so much once again. Bye-bye.